a webinar uh, entitled Protecting Rental Income During COVID-19. This webinar will be recorded. And so if you don't want to be recorded, now's the time to exit, but we will be recording for quality control purposes, as they say. And hopefully, if there are ways for us to improve, the recording will assist us. So there are some new laws that are going to affect. We're going to talk about those new laws as they impact on the business of residential rental property. And that's what this class is about. If you thought you were taking some other class, you're welcome to remain and listen. Otherwise, you might be in the wrong place. But this is a discussion about Senate Bill 91, eviction moratoria, and collecting rent from residential tenants. So my name is Clifford Freed, and I'm an attorney in the Bay Area. I have an office in San Francisco, one in Oakland. We have the largest staff of landlord attorneys in the East Bay to assist residential landlords. We are real estate attorneys, landlord attorneys. I've been practicing law for almost 40 years now. I author several publications, including articles for various rental association magazines and for Continuing Education of the Bar, which is a publication for attorneys. I will be doing webinars for other attorneys focusing in on Senate Bill 91 and the various eviction moratoria in the state of California. We represent landlords and assist them in how to collect their rents when rents are not being paid. We assist landlords in undertaking eviction actions, including the filing of unlawful detainer actions when that is permitted by the law. And we're available to assist you folks as we move forward through this pandemic. William?
Yes, thank you, Clifford. My name is William Lynn. I am the Chief Operating Officer of Advent Properties. I joined Advent about just a year ago now. I used to practice law with Clifford. I am also the company's legal counsel. And like Clifford, when I was practicing law, I did basically the same thing with Clifford's firm. And now I'm just trying to help Advent's clients on the business side of things. And so welcome to our webinar today.
I want to point out that the information that's contained in this slideshow and in today's presentation is very general in nature. For advice on any particular matter, please consult with an attorney because the facts of your situation may be unique and the law and all the regulations that interpret the law are constantly changing. And a lot of the material we're talking about today is very new. It's hot off the press. This is the first seminar that we're giving about Senate Bill 91. So you want to consult with attorneys about your particular case in the event interpretations of these new law change and evolve.
All right, let's get started. So over the past year, since I joined Advent in February last year, unfortunately, COVID has just hit us quite hard beginning March. So over the past year, we are seeing some trends affecting owners' ability to collect rents. So it varies from tenants claiming some sort of financial inability to pay rent due to loss of job or increased costs due to childcare needs and things like that, or they have to quit. Are people claiming rent strikes. We also seeing a larger number of premature termination of leases, and also we're receiving a fair number of rent reduction requests, as well as overall increased maintenance costs due to people being at home a lot more than before. So we'll go into each one of these in more detail later. And also there are way more federal, state, county, and city various levels of new laws and regulations or executive orders are applicable to landlord-tenant relationships, which make things more difficult and more costly to comply. And also, we it affects our ability to actually, some local laws actually affect our ability to impose rent increases as owners may want to do otherwise. So we'll get into each of these areas momentarily. All right, so
the first area has to do with the tenant's inability to pay rent. And from a legal perspective, when a client calls me, the first thing I question is the inability to pay rent legitimate? There are people who they don't want to pay the rent because they hear there are various programs in place and new laws in place that will protect them if they don't pay the rent. So there are people that are gaming the system as tenants, but there are also people that legitimately are financially impacted by COVID-19. There's something about COVID-19 that is causing them the inability to pay the rent. Either they lost a job or they got sick, or someone in their household lost their job or got sick, which leads to a reduction in household income and an inability to pay rent. It's very difficult to separate out the fakers from the people who really need assistance. So from the legal point of view, the law is, it's not supposed to be sympathetic. It will be when you get to court. You're going to get the tenant's going to get a lot of sympathy from the courts. But from a legal point of view, my clients want to know, is the tenant in default and can I evict? Under all the laws, the obligation to pay rent is still enforceable, subject to the usual defenses like breach of the warranty of habitability and breach of the covenant of quiet enjoyment. But under all the moratoria, it is stated that the tenant still owes the rent. And if they're not paying, it may be a default, whether there's a COVID reason or not. William?
So from the business side of things, what we started doing immediately back in March were a number of initiatives that would tend to show I would say, hopefully showing that the owners or landlords are caring and that we're working in good faith with every tenant and their needs as things come up. And so we would get either tenant would stop paying rent and not communicate as to the reason. So what we do is in those cases, we actually send a nice little follow-up message to them, and very casually. In fact, we don't actually say, "Oh, your rent is due. Please pay," that kind of things. We don't do anything like that. We basically follow up and say, "Hey, we just noticed that we haven't received the rent. We just want to check in with you to see how you're doing, and is anything we should know or we can do for you." That's one way we're dealing with that. And then if and when the tenant actually contacts us and says, "I lost my job or lost hours or whatever it is, my business has to shut down due to the shelter-in-place orders," and then we start engaging on dialogue. So we have a uniform response that we customize depending on the information they give us. So if they already told us they have to shut down their business in order to comply with the SIP orders, and we would say, "Okay, we're sorry to hear that, and we would like to work with you. The owner's willing to work with you, but we need to know a little more about how you're actually being affected." So we try to engage in a dialogue, and we also direct them to all the financial resources that may be available to them. So our uniform response provides a list of nonprofits that we know were providing financial assistance to these affected tenants. And for small business owners or business owners, we actually even provide them information on small SBA financial resources that were available during the first round of the financial relief provided by Congress. So, and also we direct them to the state unemployment office as well, because there were some updates to the changes to their qualification criteria for people who are self-employed. So we try to direct them to obtain self-help first. And the goal, of course, is to trying to get owners as much rent as possible without having to agree to some sort of rent reduction, which we'll get into later as well. So we, in all of our communication, we try to document as much as possible in writing our efforts. We would ask them for all this information first, and we engage in a conversation and before, but also at the same time, we'll try to set them with the correct expectation that a rent reduction may not be possible, depending on its individual owner's own financial situation. We ask them to consider some sort of reasonable rent deferral agreement, and we ask them to present to us what they think will work for them, given the information that they are willing to provide to us. So let's say if somebody says, I lost my income by 50%, I would like to defer 50% of my rent for a period of time, and then say, well, sounds great. Well, please let me know what repayment schedule will work for you, and we'll discuss with the owner and we'll get back to you. So that's the interactive process that we engage with all these tenants. Now, some of the tenants just don't, they're not very communicative. And so we would gently follow up every so often, and not to appear as we are chasing after a debt, or appear as we're debt collectors, but we just try to be nice and just follow up, say, hopefully they're doing well, and just want to engage in a conversation with them. That's the approach that we've been taking. And so far, with those that are willing to talk to us, it so far has worked out quite well, I would say. So we're also getting, well, fortunately for us, for our clients, we only had 3 separate tenants claiming to be on rent strikes. And one of the 3 have already given up on that effort, which is good for the owners that we serve. And with rent strikes, what we do is we don't actually engage them in their hyperbole about rent striking and what they're trying to do. We engage in the same type of dialogue with them, trying to find out more about them personally. Just so you know, what they usually do is, we actually see this in these 3 tenants. They copy and paste the same form letter that they obtained from one of these tenants organizations supporting or advocating for rent strikes, and then send that to us without anything about themselves, how they're personally affected. So we try to point that out and saying, hey, we would love to work with you, but you need to work with us and tell us how you personally being affected. And so we try to do that, but just so you know, the experience has been varied. The 2 are still, quote unquote, on rent strike. They are still refusing to work with us. So, but we continue to try to work with them in an effort to show that we are really trying to work with them, instead of just accepting their request to, really, they were asking for rent to be erased completely. So we're just not agreeing to that.
William, do you ever ask these people who are on rent strike if they're being advised by some other organization? Or
no, but I was able to find the organization that provided a template, because it's the exact same thing they provide on their website. The same.
Does it start with A and end in E, and there are 2 C's in the middle?
That's correct.
Mm-hmm. All right. So with regard to rent strikes, to quote Crosby, Stills, Nash and Young, there's something happening here, but what it is ain't exactly clear. I think that there are tenant advocates, different organizations, and lawmakers that are taking advantage of the current situation, of the situation being tenants not being able to pay the rent, landlords suffering because they need their rent money, and they're trying to make permanent changes in the laws that are not going to go away. My experience has been with a lot of the rent laws that have got into play in the last 25, 30 years. They just get piled on, more and more laws and regulations. And these laws are not temporary that we're seeing right now. We're seeing laws get extended. And I think you're going to hear a lot of tenant advocates saying, hey, this worked fine. We should always have a rental assistance program. We should always have a moratorium on evictions. We should always have rent registrations. A lot of this is permanent. You have seen in the last couple of years attacks on the Costa-Hawkins Rental Housing Act. That's the law that allows you to raise the rent when a tenant vacates. There will be an attack on the Ellis Act, probably during this upcoming November election. Voters are going to be asked to just repeal the Ellis Act completely, and that's your safety valve. If you don't want to be in the rental business anymore, the Rental Act allows you to go out of the rental business. So rent strikes are just a part of this. And I think you're going to see more and more rent strikes. A lot of the organizations that are instigating the rent strikes are very well funded, and rent strikes are not going to go away. But a rent strike is a default in the payment of rent. And I think when a lot of tenants realize that they can be sued in court for a debt collection, they're not going to want to see their credit get ruined because some tenant advocate told them to go on a rent strike. But just keep in mind that a rent strike is a political ploy, and that when push comes to shove, tenants will, like with a hunger strike, they'll eventually pay their rent. They're eventually going to eat. So don't be alarmed by someone who threatens a hunger strike. Just get some legal advice.
And then somebody had the question about what the rent strike is. I just wanted to quickly address that. It's basically tenants refusing to pay rent in the name of greater social good, really. That's what they're claiming. And at least the ones that we're seeing, that's the basis they're claiming, is that COVID-19's effect on everybody. People lost jobs, people suffering financial losses, and therefore they're working, I guess, supporting one another in solidarity. I know one prominent owner operator of hundreds of units in the East Bay was a target, was a famous target of a rent strike. All of their tenants, over 100, I think over 100 of the tenants banded together and refused to pay rent. That was quite unfortunate for that particular company. I think it also happened in San Francisco. I remember correctly, the largest single landlord, was it Veritas Investments or something like that, was also unfortunately a target of that rent strike in San Francisco. I remember seeing that.
Banding together could be dangerous, especially during the pandemic. It's considered a super spreader. Let's talk about premature termination of leases.
So we're also seeing an increased number of premature termination of leases requests, and tenants are asking to be let out of the leases early and without penalty. And so we take those things typically with a very friendly approach. So we over saying, okay, we'd like to find out a little more about why you're leaving, and we'll do what we can to work with them to help them exit their unit, because what we don't want to see is not allowing them to leave without penalty, leading to them engaging in the rent strike, for example, refusing to pay, and then still stay in possession of the units. So we usually work with the owners to make owners understand that there are certain risks associated with not working with the tenant to allow them to exit without penalty. So that's what we've been doing, and it's better to get your unit back, hopefully without the tenants owing you any money, than it is to keep them there and having them not pay anything.
That's true. So far, the record I have is one client is owed $60,000 in back rent as a residential tenant, and we're trying to do a buyout. Remains to be seen what will happen. A premature termination of a lease, when you think back a year ago, a lot of you would have accepted that, particularly when you had a tenant who is below market. You would take a premature termination of the lease, just get the old tenant out, clean the place up, rent it out for more money. What a difference a year makes. Now, if there's a premature termination of a lease, you might not be able to rent out that unit right away. A premature termination of a lease is a default. The tenant could be sued for any unpaid rent that's due during the lease term. But the concept you have to keep in mind is that you have a duty to mitigate the damages you suffered. You just can't keep an apartment open and not do anything to re-rent it. You have a legal obligation to re-rent that unit for as much rent as you can, so that the outgoing tenant who terminated his or her lease doesn't have to be obligated for damages. It's going to take you a period of time to clean up the unit, maybe make repairs. There would be some downtime that perhaps the tenant is not obligated, or the tenant would be obligated to pay for. But the key is get it re-rented. Don't let it remain empty.
All right, so we're also getting a number of rent reduction requests from various tenants. So typically we would look at the request itself. So if they're COVID related, number one, then we're taking a very different approach from those who are simply saying, hey, I'm seeing a lower rent offer elsewhere for similar properties like the one I'm residing in. I'd like to have an adjustment to my rent. So with the COVID-19 affected tenants, we of course take the original approach, being sympathetic towards them and try to work out some sort of repayment option with them. Or sometimes we actually have gone into a system where we provide some sort of rental credits, so that as not to affect the base rent that they were paying already. So it's a limited in duration. So we would usually ask, how much time do you think you need this credit for, and things like that. We try not to make it permanent with this COVID-19 stricken tenants. And if a tenant truly, in our experience, that if they're truly affected by COVID-19, they're usually seeking something very temporary, 6 months, 9 months maybe, and they are not seeking any permanent reduction. Whereas those who are seeking to take advantage of the downturn in the market typically are looking for a permanent cut to their rents. So we've taken very different approaches depending on the basis upon which they're seeking this reduction. Now, what we also try to do is, if it's a single family home or condo where we have many owners who only has one property, single family home or condo, that with a tenant seeking that, because usually they have higher rents already and they're seeing all these reduced rents elsewhere. We take a very different approach when it comes to those, because at that point we actually present it to the owner and discuss the risks of not agreeing to some sort of temporary reduction or a permanent reduction because of the vacancy it may cause, and things like that. Now, multifamily buildings, we take a different approach in that if we typically would advise owners not to consider it, because tenants talk. And if you rent it to one person and they tell their neighbors, it's going to spread like wildfire, and there's really no end to it. And so that's a problem we're afraid of, the precedent we're afraid of setting by allowing one versus another. And at that point, I think Clifford can speak to the fair housing implications of a decision to allow one tenant some sort of reduction without giving that to other tenants.
Okay, so I was going to say from a legal perspective, because this is really a business question, if you want to entertain the request. From a legal point of view, First Amendment gives the right of free speech. A tenant could always ask, and a landlord, I believe, could always say no. But the question has come up, what if you're giving a rent reduction to one tenant and not another? I think it could be done on an individual basis. It's the same thing as landlords not being required to charge the same rent to all tenants. Everyone's situation is different. There are different factors involved. People took occupancy at different times. It's just that if the person making the request is part of a class that traditionally has been discriminated against, you might face a discrimination claim if you gave a rent reduction to a class of person that is not traditionally discriminated against, and you didn't give it to a person who's part of one of the suspect classes. But really haven't seen any litigation or threats in that area yet. That doesn't mean it's not about to happen. What about increased maintenance costs, William?
So one of the most common things that we're seeing is increased water usage by virtue of people being home more, or people who are sheltering in place with some loved ones. They have temporarily had some people staying with them. And that can really dramatically increase your costs, especially I understand EB Mud has some really outrageous surcharges that they impose. And PG&E costs, if you're providing that to the tenants, that's a little less frequent, but really water and sewage usage is through the roof that we've seen. And also things break down more. We're seeing a lot more requests for water heater replacements or repairs. Laundry machines are going out of service frequently because of the increased use. People are just home and they're just using all these things, stoves as well. They're cooking more, and more wear and tear on all these appliances that are typically owner provided or owner responsibilities. And it's just overall, these costs just keep on adding up for the past year for a lot of our owners. And also, if and when the tenant leaves, we're seeing a much longer wait period before the vacancies can be filled. And that one is there is a limited number of vendors are available to handle the unit turn, to make it ready. And unfortunately, a lot of workers in the construction trade are particularly susceptible to attracting COVID. And in fact, we have a number of vendors whose workers have been stricken with COVID and having out of work for weeks on end. So those are real and real losses in terms of rents to owners, and also marketing costs. There's so many vacancies out there, and then so a lot of them are very shiny and very pretty and very new units around the Bay Area, and they're seeking tenants. And if you have an older building, unfortunately, unless your unit can somehow compete in terms of amenities and features with these new shiny buildings, the units are going to sit a bit longer. And tenants are very, very picky these days. If you don't have this, they don't want it. If you don't have that, they don't want it. So those are all increasing the length of time to fill these vacancies. And also, we're also seeing tenants refusing entry for necessary repairs, even those ones that they requested due to COVID. And they can claim COVID, and we don't want to expose our vendors or employees to exposure to COVID. So we always accommodate the tenant's request to not to come in at certain times. And that also delays our ability or impacts our ability to timely perform repairs. So we try to work with the tenant's availability, but some tenants are very difficult to schedule with. So that also adds to the cost and the length of time that it takes to get something done.
It may be possible in the future to recoup some of these increased maintenance costs by petitioning your local rent board for an operating and maintenance expense pass-through. And with that in mind, you can write to the tenant and tell them to, keep their utility use down. Obviously, you don't care about their Comcast bill if they're watching more movies during the pandemic, but let them know that your water bills, your gas bills have gone through the roof, and that you would consider at the appropriate time seeking a pass-through at the local rent board. That might be enough to prompt your tenants to keep their utility usage to a minimum.
Oh, so something I forgot to mention is there's an increased number of crimes around the Bay Area. Thieves are vandalizing mailboxes all around town. They're taking garbage cans for what, I don't know what reason, but their garbage cans are missing from properties, and that just creates more trouble for owners and tenants alike. And the issue with the damaged mailboxes is that it's a very expensive, very time-consuming process to get them replaced, and also to coordinate the USPS to get access to the key to the mailboxes. It just overall, those costs really add up. So something we're also seeing. All right.
So now we're going to segue into some of the new laws that we're seeing, that we have seen in the past year or so. And we're going to start at the highest level, which is the Federal CARES Act. This was imposed at the very beginning of COVID-19. And basically, it is a moratorium on evictions where the property involved is backed with a mortgage that was insured by the federal government, or the federal government somehow regulates the property in some way. And under the CARES Act, there's a 120-day eviction moratorium. A lot of people don't think too much about the CARES Act and the moratorium in the Bay Area, because we have much worse moratoria that we have to deal with. But under the Federal CARES Act, a 30-day notice is required when you're evicting a tenant for a non-payment of rent, instead of the usual 3-day notice or whatever notice might be required locally. California, traditionally, it has been a 3-day notice. Many of you know that there's now a 15-day notice to pay rent or quit. It's only supposed to exist throughout the state moratorium, but that's one of the new laws that I think are going to remain. I think the 3-day notice to pay rent or quit is a thing of the past, and tenants and the legal system will get used to the 15-day notice moving forward. Another law at the federal level comes from the Centers for Disease Control and Prevention. This is an organization that is set up to stop the spread of COVID-19, and the CDC, for whatever reason, believes that halting evictions will stop the spread of COVID-19. Of course, there's no scientific data to back that up. Doesn't really matter. It's very hard to challenge these federal laws, which are so-called temporary moratoria, because by the time you file your lawsuit and get into court challenging that law, the law could be over. So there haven't been many challenges. Under the CDC order, residential evictions are prohibited except for evictions that are related to health and safety of other tenants, or based on criminal activity of the tenant that the landlord seeks to evict. This order expires on March 31st, 2021, but it might be extended through the end of this year. It does apply to all cities and counties in the entire United States, except if there is a more protective law that exists on the local level. And everyone pretty much agrees that the cities in the East Bay, the County of Alameda, all have moratoria that are more protective than the CDC order. So a lot of the lawyers and landlords are just ignoring the CDC order. It's not as important in the Bay Area as it is in places like Kentucky, Montana. And I apologize if you own rental property in those areas, because you probably are being affected by this order. Okay, so now let's move on to some of the more local laws, not exactly local, but starting at the state level. William?
So over the past year, a lot of you guys, a lot of our clients have been notified that there's some new laws that went into effect. The first of which that went into effect last year, we had to comply with was a state law known as AB 1482, which required the property owners to give certain notices if you're exempt from that law, and to existing tenants. That compliance date was last summer. We have complied with all of that. There's a special notice that goes out. So we actually had to go and engage in conversation with all our owners as to the ownership of the property, and then send out the notice to all the affected tenants. And after that, the state law known as SB, I think it's AB 3088. And then,
It is.
Yeah, and then that law requires another notice yet to be served in last fall on all the tenants who have not been able to pay rent due to COVID-19. So we did another round of notice. That one doesn't require too much other than just notifying them of the existence of the law, that they can be evicted for non-payment rent for 6 months last year and things like that. Now, the latest one is this one, the major topic today, which is SB 91, which was just passed, I believe, at the end of January, and which extends and modifies SB, so AB 3088. So, and there's another notice that we have to give to tenants who are affected. So we are in the process of getting all that done this week, and we'll hopefully get everything mailed out by Monday. And those things are kind of tricky, which Clifford will talk more about the actual requirements and the impact.
So there have been a lot of new residential landlord tenant laws in the past year or two, and these are some of them. There's so many, I get confused between Assembly bills and Senate bills. So we'll have to correct that slide for future talks. It's difficult for attorneys and property managers to keep track of all these laws, especially because we practice in many different cities, and every city has its own set of rules and laws, and some of them interact with these state laws, it does get very confusing. So we can imagine how confusing it is for mom and pop landlords, people who just have a one or two rental units. It's really hard to keep up with these laws. So what we're doing today in this presentation is sensitizing you to some of these new laws so that you can spot issues as they come up and know which ones you can deal with on your own and which ones you might need to reach out for assistance in the future. So with all of the new rent laws, the moratoria that are coming out, they're all very clear to say that they don't require the landlords to waive rent or to give up rent. That landlords still have the ability to go to court at some point in the future, at least, and sue for the rent debt, the rental debt that is owed. What these laws are saying is that they are going to restrict you from evicting tenants based on non-payment of rent that is connected with a COVID-19 financial reason, COVID-19 financially related reason. That's what they are regulating. But you could always hold on to your right to sue in court later on, either regular court or going to small claims court. Not that small claims court isn't a regular court. It is a regular court. We're going to talk more about it in a moment. But a lot of tenants, when they hear the landlord is going to get tough on insisting on the rent be paid, if the tenant gets served with a lawsuit for a rental debt, they know that's going to impact negatively on their credit. And a lot of times that will prompt a payment from the people who are gaming the system. Obviously, if someone really is affected by COVID-19, and hopefully you'd be sympathetic in those situations, you're not going to be able to successfully sue those people. You could legally sue them in court, but you can't get blood out of a turnip. So with those tenants, maybe they would agree to move out, the ones that have no money, but the ones that do have an income, do have money, and can afford to pay the rent, they're going to be frightened by the prospect of their credit being adversely affected. So the first thing that Senate Bill 91 does, and this was passed at the very end of January of this year, it was passed by the state legislature, signed by the governor almost the very next day. They changed the name from the Tenant Relief Act of 2020 to the COVID-19 Tenant Relief Act, because they realized that the law was going to slop over to 2021 and possibly beyond. Actually, the new law does affect, that does to some regard go over past 2021 into 2025. So they just dropped the year on the name of the act and renamed it.
So I would say that I have personally read through many of the words in SB 91, the text itself, as I know, as did Clifford. So it does many things. It extends the protection to tenants that was provided under AB 3088 through the end of June this year. That should have been 2021. Apologize for that typo. Originally, the coverage time, the protection period ends at the end of this past month, January 2021. So they added another 5 months to the protection period to tenants. And imposes additional penalties on landlords who violate the law. It specifies, I think, between $1,000 and $2,500 on a violation, and it regulates the collection of rent debts, and which we'll get into more details about those regulations. It's quite interesting. And also you cannot, it limits how much late fees you can actually collect and things like that. Now, some cities already limit that. For example, Oakland, if I remember correctly, does not allow owners to impose late fees during this time, during the pandemic. And also, it additionally extends the small claims core option for landlords to collect on the rental debts. And well, unmasking unlawful detainer filing. So what that means is back, California had a law that basically said all unlawful detainer cases, all eviction cases shall not be available to public view until there's a judgment rendered in that's against a tenant, a defendant, until at least 60 days after that. And this actually changes that a bit. And then there's also new notices we got to give to tenants. There's a 15 notice and also the informational notice, which the informational notice is due before the end of this month. And the 15-day notices are to follow those informational notices. And actually the informational notices literally direct the tenant to a state-sponsored website that tells them that landlords can't do this, landlords can't do that. You're protected, and in big bold letters. And also it preempts, so basically supersedes local eviction laws that relate to COVID-19. And then there's that new federally funded state administered rental assistance program, which we'll get into the details very soon. Let's see.
So I would joke about AB 3088 and how many words were in that statewide eviction moratorium and how it far eclipsed the words in the Costa-Hawkins Rental Housing Act. Well, AB 3088 was nothing compared to SB 91. There's like 90,000 words in this law. If you're up for the challenge, you can go online and look up the actual law. It's very difficult to read. It's very confusing. Lawyers are already beginning to argue about the meaning of some of the words, and William and I will get into some of those arguments in a moment. But it's a horrendous piece of legislation, and we're going to give you a little taste of some of the issues that are being raised right now. So tenants who failed to pay the rent, some or all of their rent between March 2020 and August 2020 can never be evicted based on non-payment of rent that's related to COVID-19. That's assuming they returned a declaration, but even then, these people can never be evicted. So that's if you have a tenant that didn't pay rent during that period, give it up. You won't be able to evict them, but you will be able to get your money. Well, you'll be able to sue in court. It'll be considered a consumer debt, and you could bring a lawsuit in court, small claims or regular court, to recover that money. Tenants who failed to pay the rent, some or all of their rent for the period of September 2020 through June 30, 2021 can be evicted if they fail to return a declaration. And we're going to talk about this declaration in a moment. It's a specialized declaration. And or they don't pay 25% of their missed rent payments by June 30, 2021. So the state law actually gives them some time to pay 25% of the missed payments.
So we have mentioned the 15-day notice, and that is a special notice that was created originally under AB 3088, and that's continued to be used. Now, you're supposed to, under AB 3088, you're supposed to give a 15-day notice for each month. I believe, if I remember correctly, that tenant had missed rent due to COVID-19. And you have to serve that, and that's on top of any other notices that might be required by your by the local, I believe, the local jurisdiction. Am I correct, Clifford? I believe that is in addition to those local requirements.
You have to still comply with a local requirement, but there's some controversy about that as well. So it really has been moot in places like Oakland and Berkeley, where you can't file any unlawful detainer anyway. San Francisco, we created a hybrid 15-day notice where we managed to incorporate required words from San Francisco's rent ordinance, and we kept the required language from the state moratoria.
And just, what we have not served any 15-day notice because it is a tricky situation that we're informing all our owners who are thinking about that to consult with an attorney like Clifford in order to make sure that your notice complies 100% with the locality and the state requirements. And so we do have the 15-day notice forms from California Apartment Associations. But again, like I said, we do not recommend just using the form without having checked with the whether or not the form by itself, in and of itself, complies with all the requirements that are required so that you can actually be in compliance with the law. So so the rent, when they say rent, rental debt includes utility payments that are obligated to pay under the lease. Also includes any sort of parking fees, or they're obligated to pay under the lease as well as pay rent if you have one of those. So, but it doesn't apply to late fees and things like that. Or I don't believe it actually also does not apply to insufficient fund fees and things like that either. I don't quite.
So the thing to keep in mind is that there are different 15-day notices out there. Some apply to a breach of a payment other than rent. There's some notices that apply to breaches where the CARES Act applies. And then there are new notices as of February 1, 2021. So you need to be using the right notices, and you can get the right notice forms from your local apartment associations, from the California Apartment Association, or from eviction attorneys who are keeping up on the various forms that are being used. So the 15-day notice, it's a non-payment rent notice. It's not it functions like a 3-day notice to pay rent or quit, but it also includes a blank declaration for the tenant to fill out if they believe they're not paying rent due to some COVID-19 related reason. And they have to return that form to the landlord to get the protection of the statewide moratorium. The declaration gives the tenant an opportunity to explain that their non-payment is related to a loss of income, increased out-of-pocket expenses, increased health-related expenses for themselves or members of their household, or that they're having to care for family members, and there's a catch-all for other circumstances. So it's usually related to an illness or from a loss of work. That's what we have been seeing. There is an exception where a tenant cannot claim a COVID-19 related reason if they're making too much money, but the only time a landlord can ask for documentation is when the tenant is considered a high income earner. High income means the household income is $100,000 or 130% of the median income for that area. The odd thing about landlords asking for this documentation from high income tenants is that the landlord is required to know ahead of time if they're high income or not. And how does a landlord know that? Well, the expectation is that you have something in your files, a rental application that shows their high income and that they're making at least $100,000 or 130% of median income for the area. If you don't have that kind of proof in your files, you shouldn't be asking for the proof of high income proof of high income.
So if I may, I just add something about that proof in the landlord's file. So we would have, say, application materials in our system that suggests that the tenants, now tenants or then applicants, had certain income level when they applied. As you may know, people do change jobs, and the longer they are a tenant, they have been a tenant, the less likely that job or that income would have remained. So I'm not sure how useful that information is. I have looked at many of these in the past discussions with some owners as to tenants' ability to pay rent and things like that, but I'm not sure really how useful they are.
Okay, so we're going to pick up the pace a little bit here. We have a fair number of slides to get through. Let's talk about the protected period. This is the time between March 1, 2020 and August 31 of 2020. That's the period of time where you're probably not going to be able to evict a tenant if they didn't pay the rent due to a COVID-19 financial distress of some kind. For rent that's due during the protected period, the tenant must be served with a 15-day notice to pay rent or quit, along with a blank declaration. And the 15-day notice notifies the tenant that they cannot be evicted if they return that declaration. The old 15-day notices that address this time period are still valid. Then there's something called the transition period. The transition period is a time between September 1, 2020 and June 30 of 2021. For rent that's due during the transition period, the tenant must be served with a 15-day notice as well. The 15-day notice must notify the tenant that they cannot be evicted except as allowed by law, and we're going to talk about what the law will allow moving forward if they return a declaration related to their distress. The tenant must also pay 25% of the rent that's due between September 1st, 2020 and January 31, 2021. And they have to return the declaration by January 31, 2021. That was under the AB 3088 that has now been extended. So the transition period is the time between September 1, 2020 and June 30, 2021. So now I'm talking about notices that are served on or after February 1. That's after this new Senate Bill 91 went into effect, and there's new language that has to go into the 50-day notice. So for notices served after February 1 of 2021, the tenant again must pay 25% of the rent that came due or will become due between September 1, 2020 and June 30, 2021, and they have until June 30 to pay their rent. They still have to return a declaration within 15 days. And the new thing that we're going to be talking a lot about in just a moment is the tenant must be notified of a new rental assistance program that's available in the state of California. Again, notices that were served before February 2021, before this new law went into effect, are still valid. So California has something they're calling the rental assistance program, thanks to money that became available from the federal government. And the program it's being formulated right now. Regulations are being drafted. We're learning more about it in bits and drabs. What we do know is that California received $2.6 billion from the federal government to implement this program, and that's to pay for unpaid rent due to COVID-19. And that's a fair bit of money. According to local surveys about who's not paying their rent, there's not a lot of rent that's unpaid in the Bay Area, relatively speaking. But to give you an idea of how much funds are available under this program, for Alameda County, $30 million is coming from the federal government. Another $32 million is coming from the state of California, for a total of $62 million. Fremont is getting a total of $15 million, the city of Fremont, from the federal government and from the state government. Oakland, California, $13 million from the federal money and $14 million from the state of California, for a total of $27 million. So there's a lot of money that's available under this program. With the tenants' cooperation, Landlords can apply for this assistance. The tenants can apply for this assistance on their own. And the controversy here is that under this program, the government will pay up to 80% of unpaid rent if the landlord waives the balance. Now, initially, a lot of landlords looked at this and said, well, that's not bad. If I get 80% of the rent that's owed, remember that theoretically the tenant's already paid 25% of the rent. We're talking about the unpaid rent, the rent debt that's owed. A lot of landlords said, well, 80% of the rent is better than nothing. But what this program says is that the government is only going to pay up to 80%. The landlord agrees to participate in this program, they may not get 80%. They may get 60, 50, 40, 35%. We don't know. And that's problematic. If a landlord refuses to participate in the program will pay the tenant up to 25% to pay for rental debt. So William and I, this was an area where we've been debating over the last day or so, because I thought that the program was going to pay 80%, but now I'm not entirely certain about that. William, you want to comment on that?
So I dug into the weeds a little bit more, and the legislation was rushed through, so the writing isn't great, and so it leaves a bit of ambiguity as to what the landlord may be entitled, and also depends on the tenant's priority level. So there's just a lot of uncertainties, and I've been looking at the state's website on this, and there's little, if any, guidance as to how and how much a landlord may expect to receive. So it is so it's still up in the air right now, and I believe personally that you could get way less than 80%, but if you were to accept that money, except for the minimum 25% if you refuse to participate, I think that you actually may get less than that and still have to forgive the remainder. So, but we have to wait to see what the program administrators actually provide to owners once the program is up and running. As of today, it's still not fully functional yet. So you can always go to the website. I think it's on the next slide that Clifford has provided to look for yourself.
So one of the questions I'm getting already from my clients is this program mandatory? According to the California Apartment Association, it might be a mandatory program where you don't have an option, that you have to cooperate with the tenant and you have to take the money that's being offered. The California Apartment Association's position is based on the fact that pre-existing law forbids discrimination based on source of income. And Senate Bill 91 specifically defines money under this rental assistance program as a source of income. The problem is that the landlord is being asked to waive what the government is not paying in terms of rental debt. And I think, in my opinion, that therefore the program is not mandatory. It's optional with the landlords, but we're going to be hearing more about that in the future. So here's a website that I found very useful if you want to keep up to date. Those of you who are not members of a local apartment association or the California Apartment Association, if you go to this website, housingiskey.com, there is some useful information there, and they claim they're going to be upgrading as we move forward. So there's a lot of money for this program, and United States Congress is thinking about adding more to this program. So hopefully there will be enough to pay the 80% of the rental debt, but we just don't know at the moment. So let me talk a little bit about unlawful detainers. The law says that for the most part, unlawful detainers cannot be filed in California before July 1 of 2021, unless the tenant was guilty of an unlawful detainer. That is, they didn't pay the rent or just holding over and that was completed before March 1st of 2020. There have been landlords who are waiting to do their evictions from before the official start of this state of emergency. And that's because locally the courts have closed down. They won't process eviction actions. You can also commence an unlawful detainer under the state law, maybe not under Oakland's law or any other local law, if the tenant fails to provide a declaration or pay 25% of the rent that's due. And also under state law, both under AB 3088 and Senate Bill 91, the just cause protections under state law were extended to all property in California. Doesn't have a big impact in places like Berkeley, Oakland, other areas that already had their local eviction control, because that's what's going to stop any other kind of eviction in the state of California.
So
William, you want to talk a little bit about the informational notice?
So yes, so the informational notice that we have served already on all the affected tenants were due before September and the end of September 2020. And the basic just tells tenant that you have these rights, you're protected from eviction if you owe rents between March and end of August last year, and then going forward, it gave the information that were then current under AB 3088. And so we're doing an updated notice now under SB 91, which is a notice that we have to give now, telling the tenants that you're now afforded additional protections under this. And now this only applies to residential tenants. I just want to make sure that's clear. We also have a small number of commercial tenants who are affected and the owners affected by commercial tenants default, but these notices are not required to be served on commercial tenants. So
the old informational notices that you served last, what was it, September, those are still valid. But as for rents that become due moving forward after February 1st of this year, you should be serving this new informational notice form that tells tenants their rights. State of California decided that you folks are the best people to tell tenants what their legal rights are. And if you want a copy of this form, we have posted it at our website. At the end of this presentation, we'll have our website posted, but you can go to our homepage and download a copy of this form, as well as a copy of the Senate Bill 91. That should be available there as well. You serve this informational notice in one of several different ways, but simply mailing it will suffice. It's okay to just mail these notices out to your tenants. If you're gonna just post it on the premises, you probably also want to mail a copy. So at a minimum, I would say just mail these informational notices to your tenants who have missed a payment during any part of this pandemic. Just send them the new notice if they missed a payment, because it's going to let them know what their rights are. And if you don't serve this notice, it's going to hinder your ability to collect rent or do an eviction in the future.
So if I may just add quickly about that, is that we're serving these notices. We're also providing them with a copy and also email if we're already engaged in conversations with them already about their need for assistance. So we're doing both just to make sure that we cover all our bases.
So a lot of landlords and landlord advocates thought that Senate Bill 91 was horrible. That remains to be seen. We'll see how it all plays out. But just to point out some of the good things that are in Senate Bill 91, possibly 80% of the tenants' unpaid rent will get paid by the government. For those of you who are just looking for your rent money and don't want to get involved with any evictions, that might be a good thing. Also, any local moratoria regarding COVID-19 rent debt is preempted. There have been a lot of places like San Francisco that are constantly trying to one-up the state and make it tougher on landlords. And they can't do that now. There's something in Senate Bill 91 that preempts any local ordinance that messes around with COVID-19 rental debt. The unmasking of the unlawful detainers in other cases was helpful. And I guess the other good thing is it's more regulations to keep me and William busy. And we both like staying busy.
So as I understand the law, you're being asked to forfeit 20% of the rents that you're owed. Now that's a minimum forfeiture that you have to agree to if you agree to accept money under the new program. It's just it is something that each owner will have to determine for himself or herself whether or not that is acceptable financially, and we really can't really opine much about that. And new regulations are still coming. We still don't know the extent of how it's done, and the way the monies are being. So also the SB 91, I think we haven't talked about this, is that it puts tenants into minimum two different priority brackets. So the tenants have to qualify under the income guidelines that state has determined, and you have to make less than 80% of your area median income before you can even qualify. And after that, the priority number one is given to those who are impacted, who are making less than 50% of that median area income. And then followed by another group of tenants who were historically disproportionately affected by COVID-19. So that's a very murky area that we really do not know what they actually meant by that. So so this is a lot of things for owners to consider. At this point, we don't really have a whole lot to consider other than these basic requirements. So it is something that we're continuing to learn about as they become available, and Clifford and I both are learning it as the state make these information available to us so that we can better educate ourselves and help the owners that we serve. So that's it is unfortunately it's an ongoing challenge for everybody.
So under the new law, there's a lot of interaction and intersection and overlap and contradictions. And another thing that's making my job a bit difficult is figuring out what law landlords have to comply with. But for the most part, city and county eviction moratoria that was put in place as of August 19 can remain in place unaffected by Senate Bill 91. City and county moratoria put in place as of August 19, 2020 cannot be extended beyond June 30 of 2021. And no city or county moratoria can be amended or adopted after August 19, 2020. After June 30, 2021, cities and counties can adopt any moratoria they want. So you may sit there waiting and say that, okay, come July 1st, I'm scot-free and none of this applies. Well, surprise, surprise, cities of Oakland, Hayward, Berkeley, they may decide to impose long-term moratoria. And also the state of California could extend this June 30 date as well. So one concept that's important under the law is documenting any tenant assistance. There are several requirements under Senate Bill 91 that landlords cooperate with the tenant in getting rental assistance, and if they ever go to sue the tenant in court for the debt, that they have to attach proof that they provided some assistance to the tenant in good faith. And what that means is that the landlord investigated whether governmental rental assistance was available to the particular tenant, or actually seek governmental rental assistance for the tenant, or cooperate with the tenant's efforts to obtain rental assistance. So the landlord's going to have to show that they did one of these three things before suing for their the rental debt that's owed. And I think what I'm leaning towards is advising my clients to actually seek the government assistance for the tenant, because that way you can show that you complied with this the requirement. Whereas if you just investigate, the tenant will say that they didn't know you investigated, or they'll deny you investigated. Where if you actually seek the assistance, you can attach paperwork showing what you did to seek that assistance. And also cooperating with the tenant. A tenant is going to take the position that you didn't cooperate with me. So I think the easiest thing for the landlord to do is actually seek the governmental rental assistance for the tenant. And hopefully the tenant will cooperate with that endeavor.
Okay, so this requirement to document the whether or not the landlord has cooperated with tenants and seeking governmental assistance will apply to any action that you may decide to pursue in small claims court later as well. Now, it doesn't apply to unlawful detainer cases, but if you decide to go through the small claims court option, then you also need to have gone through this process as well. And so this is the basic information is right here on the slide, but just that's the number one differentiation I think owners should keep in mind. And so I believe this requirement actually applies to this particular state assistance program, which I'm not sure if Clifford agrees, because I know some cities, for example, cities of Hayward and Fremont last year have provided city-provided assistance to those who qualify. But I don't believe this particular requirement applies to those assistance programs.
I think it might apply to any rental assistance program. That's how I read the ordinance.
Because if that's yeah, so that is a question that we may have to wait to find the answer.
So let's move on to the next ordinance, which I think is a bigger problem than the moratorium set forth in Senate Bill 91. That's the County of Alameda, not the City of Alameda, not the City of Oakland, but the entire county passed a law that puts a moratorium on evictions. And it provides that this ordinance is a defense to any unlawful detainer action in court. It's an absolute defense. Now, what's really sinister about this ordinance is that it may never expire. It says expires 60 days after the expiration of the local health emergency, but who decides when the local health emergency is over? So there really is no deadline here until the county supervisors say it's over. And that's a very dangerous thing. There was also a comparable commercial moratorium that expired at the end of December of last year. But this is the ordinance that's preventing the filing of unlawful detainer actions right now in all of Alameda County. The judges are relying on this language and saying, sorry, we're not going to allow an eviction. There's an exception if there's a health and safety related issue. Here are some of the other exceptions. The landlord is invoking the Ellis Act. That would permit an eviction to go forward. Theoretically, I still think I would have to convince a judge in the Alameda County Superior Court that the Ellis Act is untouchable and exempt from the county ordinance and from Senate Bill 91. There is an express exemption if the unit has to be vacated based on an order issued by a government agency or court. Well, that's not going to happen. And then third, and probably the most applicable, is the continued occupancy by the resident poses an imminent threat to health or safety. If you can prove that to a judge, they will allow you to move forward with your eviction. There have been a few on this basis in Alameda County. There have been a few evictions, unlawful detainer actions last year because the defendant was not a classical tenant who rented the unit. Maybe they were a squatter. Maybe they were a borrower who was foreclosed and were holding over in possession of the property. So those kinds of evictions are going forward, but very few of any other evictions. A lot of my colleagues who practice evictions in the East Bay are hurting badly because of this ordinance. It does not permit them to do evictions. There are certain remedies that are available for landlords who violate the ordinance. Moving a little bit quicker here. So the Alameda County Superior Court, again, they're pretty much shutting down all the eviction actions. I don't know what those judges are doing nowadays, but they used to have a slew of judges over at the Hayward Hall of Justice doing evictions, but not at the moment. We'll briefly go over some of the new city laws that went into effect, starting with the city of Oakland.
So as I mentioned before, City of Oakland has its own special law that prohibited the charging of, for example, late fees and no rent increases either. Now that is on, you are still allowed to do your CPI increases as allowed under the existing rent ordinance in Oakland. But just so you know, we have a blanket suspension on all our rent increases. As to engender more tenant goodwill. We have stopped issuing notices, 3-day notices and things like that. We're also not renewing leases because we want to give the tenants the ability to leave, freely leave if they feel that they can no longer afford the place. So a lot of things that we're doing was actually before what City of Oakland had imposed on the tenants, on the landlords rather. And so we are not proceeding down the path of with an eye to evict a tenant. Currently, at least, we're not doing anything to show that that's what we're doing. We're showing that we're trying to work with the tenants so they're keeping their homes and by helping them any way we can without trying to create a large burden on the owner. It is a very difficult thing to do, I would say. And City of Berkeley is similar. That you cannot evict. So we're doing everything that we can, try to avoid any sort of tenant's argument that landlord has not worked in good faith to work with us. So we're keeping an eye on all these developments. It's just that there have been some really weird schedule when it comes to the owners, those cities, and when they are deciding when to implement new laws or not. And so we tried our best, but at the end of the day, when in doubt, we always go to Clifford's firm and ask for actual clarification as to whether or not there's any particular restriction on anything that an owner would like to do or what we would like to do. Because it's really, really difficult to keep track of all these new laws. And so let's see.
I think I'll point out that with Oakland and Berkeley, the way they instituted their laws, there's really no expiration date until their city councils say it's over. So that's problematic in Oakland and Berkeley. There might be a moratoria on evictions in those places for a very long time.
Yes, and City of Hayward also has its own laws, as you can see, and again, like I said, because of some of the cities not allowing us to impose late fees, we actually just stopped imposing late fees. Period. Like I said, and we actually try to use that to demonstrate to the tenants that we did it way before these cities imposed these requirements on us. Because as a way to work with them, our willingness to show our willingness to work with them and things like that. Yeah, so that's some basic information there for everybody to see. Now, future rent increases, we get this question a lot. When can I impose a rent increase? Well, it depends. It depends on where you are. It depends on whether there's local restrictions. In general, we are not recommending any rent increases until at least we have a clear idea as to when the COVID-19 emergency may be ending. So I think that depends on what the governor's office is going to do, and when they do it, and also after that the emergency is over. I think it's most wise to work with qualified attorneys to determine what, if any additional language that you must include in your notice, because I'm sure that some of the cities are trying to come up with additional way to discourage rent increases.
So one thing that we were hopeful was that landlords would be permitted to go to small claims court starting March 1st of 2021, because under AB 3088, that was the starting date for landlords going to small claims court. And now that date has been extended, but I'm still an advocate for landlords going to small claims court to recover their rental debt. So we're going to talk briefly about small claims court. If that's something that any of you would like to do, there are going to be different classes and presentations coming up on how to navigate the small claims court if you're pursuing a COVID-19 rental debt. So it was the intent of the legislature in passing AB 3088 and Senate Bill 91 to give landlords the option to litigate their disputes over non-payment rent during this period of time. The laws make changes to the general and historical rules in small claims court. You will be allowed to seek all unpaid rent. There used to be a limitation of $10,000 per claim. That is being lifted for COVID-19 rental debt. You will be able to file your small claims court actions beginning August 1st of 2021. The old start date was, I thought it was March 1st, maybe it was February 1st. But it's now, you'll be able to go to small claims court on August 1st. And many years ago, just before I started practicing law, landlords were able to go to small claims court and actually sue for unlawful detainer. So there was a time before my eviction industry got started when landlords would go to the people's court and they would get a judgment of possession in small claims court. That all went away, and it became more difficult for landlords to do their own eviction cases. So this is kind of like a welcome relief. You'll be able to go to small claims court and seek the rental debt that you're owed. Small claims court, for those of you who have not been there, it's a special court where disputes are resolved quickly and inexpensively. The rules they're simple and informal, and there are a lot of forms that are available on various websites that you can fill out. Now, William, you've acted as a judge in small claims court. So is there anything you want to add to a small claims court being a good place for landlords to litigate?
So yes, I have served as a judge pro tem in San Francisco Superior Court Small Claims Court Division. The issue with that is small claims court, unfortunately, unless you have a designated small claims court judge, you may be getting people like myself who serve as judge pro tems. And just so you know, the way we decide things are all over the places. And so you may not get the same result on the same similar sets of facts from two different small claims court judges. So that is one realistic risk that you will be taking if you were to go to small claims court. That's really the number one thing I would say. That if you lose, I think we will cover that, correct, Clifford? If you lose,
we're getting to that. So William is one of the good pro tem judges. If you do run into William and he's wearing the robe on the bench, that's a good thing.
It's the problem is that there's I've seen personally there's a lot of there's a knowledge gap, I think, among a lot of the pro temps or commissioners, and when it comes to landlord tenant matters. Even though the commissioner or judge pro tem may claim that they are familiar with this area of law, a lot of them are not, to be honest with you. So that is a tricky thing. Now you don't always have the right, by the way, to object to have your case heard by a judge pro tem like myself or a commissioner of the court, and to have a regularly scheduled a judge hear your case. But that delays your ability to have your case heard. So those are the only things I can add right now.
So as we mentioned before, the jurisdictional limits have been expanded. You could file more than 2 claims for rental debt, and there's no dollar limit that's being imposed. William, can you bring your attorney? Can I go to small claims court and represent any of the listeners here today?
Unless you're on appeal, you can't. You cannot have an attorney. In fact, that's one of the cardinal rules. Even as an attorney, if I were to say, let's say Clifford and I are in the same law practice, and if we were to go to small claims court on a debt that's owed to the law practice, I cannot actually go unless I'm a partner in the case. There are some heavy restrictions on attorney appearances in small claims court. So in that case, so even, I mean, there are also additional restrictions on on plaintiffs who are a corporate entity. So LLCs or corporations or partnerships, there are additional forms that you must file. You have to explain yourself as to who you are. Typically, small claims just don't welcome attorneys unless they're on an appeal. So
that doesn't mean you can't talk to an attorney before you go to small claims court. And if you're suing for, before I talked about a client that was owed $55,000 in back rent, I think it's in your best interest to speak with an attorney before you file in small claims court for that large of a debt. Buying a 1 hour of a lawyer's time might be very beneficial to you. You don't want to lose that claim on a technicality. So there are lots of forms that are available in small claims court. You don't want to use any of the unlawful detainer forms that are available on the different judicial websites. The claim you're filing is a form SC 100. So you could look that up, Google that, look at the form, see what's involved. It's really not that complicated. Small claims court is good. The tenant won't be there with an attorney. You act as your own attorney, but you're going to have to know some of the procedures. And while the court will say at the very beginning, William probably gives this speech, they can't help you. They don't want to see you back there again on an appeal or having to start over. So the clerks are very friendly. The judges are very friendly. It is possible for you to represent yourself in small claims court.
I would want to add this, if I may, is that the rules of evidence do not apply, normal rules of evidence. So you could bring all the hearsays that you like. Now, it's best to have witnesses with you if you have them available, even though small claim judges are allowed to read statements, out of court statements. It doesn't really add a whole lot unless to the value of your case. And then the real problems with most small claims litigants is that it's having to do with service issues, service of process issues. But once everybody's shown up, then you really have just gone over the most difficult hurdles. So just make sure that you are clear, concise, and not gibbering about things that are not related to the case. Because each case is only afforded 10, 15, 20 minutes max. So you want to make sure that you give all the information to the judge in terms of filing and things like that, so that they can actually follow what your claims are rather easily. Otherwise, you may just lose because the judge can't determine what you're actually claiming. So that's very important. Yeah.
So we're starting to drop a few people out. We're going to talk a little bit more about small claims court before we take questions, just so you folks have an idea. If you could hang in there. It'll be maybe another 5 minutes before we get to answering your questions. And we have quite a few that we're looking at right now. William, let's get through these small claims court slides. Go ahead.
All right. So again, small claims court is actually, it's not, it's a lot like what you see on TV, Judge Judy, except for the large audience. Typically, there are very few people in the courtroom. It's very informal. Judges tend to allow you to speak as much as you want, but don't take that too liberally, and do focus on your case. And more concise you are, the better. And let's see. And cheap filing fees. Service is pretty straightforward. The forms, all the forms that you need are on Judicial Council's website. That will be available at courts.ca.gov. And that particular website also gives you a lot of very informative information about small claims court. I know at least in San Francisco Superior Court, there is actually a small claims court counselor in the self-help center. Every Superior Court has some sort of self-help center for litigants. So you can always get some useful information from those people. I'm sure they once this process is opened up to landlords, their self-help people will be trained to give you information that you need, but don't take their information as proper legal advice, because they can only give you information, and they're usually non-lawyers and who are just there to give out the same information that you have to give to everybody.
William, do you think those people are working right now during COVID-19?
I know some of them are. Actually, the courts at least San Francisco, they are resumed normal operation. They are there. You may have to make special appointments. You can no longer queue up in the long line that you used to be able to. But I think they're still available. It's just that it takes longer to get an appointment, I think, these days.
Well, it's going to get more difficult to get one of those appointments as you get closer to August 1st, when the gates open up to landlords to small claims court. So some of the disadvantages of small claims court is that if the landlord files a claim and loses, the landlord cannot appeal, but the tenant can appeal. Defendant always has the right to appeal. So that's one of the disadvantages. You don't get two bites at the apple. The tenant does get two bites at the apple. However, if you do appeal, if the tenant files an appeal, you can then bring a landlord, an attorney in to represent you on the appeal. The other problem is that a lot of tenants are moving out of state, skipping out on the rent, and in small claims court, you can't serve defendants outside the state of California.
So I want to say a little bit, if I may, just quickly about the appeals and things like that. So an appeal in small claims court is literally a second bite at the apple. It's not the typical appeal as you may understand it. The new judge, the appellate judge, the appeal judge, is going to hear the case anew, as if the first trial never took place. So that's what I meant by second bite at the apple. And so if you get a court commissioner or judge pro tem, I would suggest that you do not agree to having that person hear your case, simply because if you get a regular judge, it's less likely that another judge is going to overrule the previous judge's decision. That's generally the case, but there are always exceptions. So
again, there'll be lots of classes and presentations and webinars on landlords going to small claims court to collect their debt. Those are coming up. We just wanted to give you a little bit of a taste about what's happening. What you need to know about going to small claims court, you need to plan ahead starting now, because buried in Senate Bill 91 is the concept that if you don't accept money from the government under the rental assistance programs, when you go to court, a judge, and arguably in small claims court as well, a judge could say, well, I'm going to give you a judgment for all the back rent you're owed, but I'm going to reduce it by the amount of financial assistance that the tenant was eligible for, because you should have taken that money. So this is going to be an interesting decision that you folks have to make. We don't know if the judge will reduce the award of back rent. All Senate Bill 91 says is that the court may reduce it. And it puts you in a tough position of accepting financial assistance or not, because when you go to court and sue for all your back rent, you may face the wrong judge telling you, too bad, you should have taken the financial assistance. There are no standards for when the judge can reduce the amount of damages. It appears to be in the judge's sole discretion whether to reduce the award of back rent that you're owed due to your failure not to take this financial assistance. That's a big point of Senate Bill 91. Okay, so now We only have 28 questions to answer. Let's see here.
Clifford, I can read some out for you.
Okay, that would be great.
Tom asks, are you seeing any eviction lockouts now in Alameda County, specifically Berkeley? They won an eviction in February, but the tenant's been there since because it was scheduled for the week of shutdown.
No, we're not. We're seeing zero because Alameda County Superior Court is following the Alameda ordinance, and they don't care when the eviction was filed, when the writ of possession was issued. They're just not issuing judgments, writs of possession. The sheriff is not enforcing writs of possession. So the answer is no, we're not seeing evictions in Berkeley, but it doesn't mean landlords shouldn't try if they feel they fit some exception. You can always go to the judge in the case and make an application to have the writ issued and an order instructing the sheriff to carry out the lockout.
Next question is from John Cranston. If a tenant refuses entry, is the landlord on the hook for the delay? Like, could the tenant claim that their item was not fixed and get some benefit for that?
Well, it's a common tactic for tenants to not allow the landlord in. So they make a complaint, which puts the landlord on the hook for dealing with a habitability issue. Then they don't let the landlord in, claiming, well, it's inconvenient, it's too late, or I don't want to catch COVID from your property management team or your vendors who are coming in to make repairs. And it's become a real problem. In those situations, I think the landlord needs to document what's happening. Hey, you asked me to fix this. I tried to fix it. You're not letting me in. So, the ball's in your court. It's your problem. Essentially, the tenant is creating the problem. And that evidence could be used in court later on.
Okay, next question is from Steve Mock. If a tenant did not pay back rent and leave the property quietly, how can the landlord pursue legal actions against them if the landlord does not know the tenant's whereabouts?
So there are resources available to property owners and property managers on locating people. It's pretty hard to hide nowadays. So contact a lawyer or a skip tracer or an investigator. They can find people.
Okay, Tingwei Huang writes, how does the government know if the reason is COVID related for non-payment? Furthermore, how do we know if a tenant is going to miss rent in the future since covered period is all the way to June 2021?
The government will rely on the declaration submitted by the tenant. So if the tenant is willing to lie, I suppose the government's going to give them a check.
Christina
the government was giving checks away to prisoners, so I'm sure they're going to give checks away to tenants who claim they're affected by COVID-19.
Christina asks, what are they talking about for the income requirements? Is it county, city, block?
William?
So I looked into this recently. They say area median income. So the state actually has a special memo that's currently available on the housingiskey.com website. If you go to that website, on the very top, there's a AMI calculator. If you click on that, the calculator is not yet live or operational, but there is a memo from April 30th, 2020 from Mr. Zachary Olmstead, Deputy Director of Division of Housing Policy Development of the State of California Business Consumer Service and Housing Agency. And that in that particular document, it provides median income limits for Alameda County, Oakland County, all the counties. I believe based on this, it's on the county level. And so they will be looking at this on a county level at the very minimum. And so Alameda County area median income is 119,200. Now that is based on essentially a 4-person household. Okay, so you can go and find the counties are applicable to your property on that, but the actual details are still forthcoming. So that's what we have right now. So those are probably good numbers to keep in mind.
Okay. Christine asks, AB 3088 and SB 91 apply to properties with federally backed loans. What if the property is free and clear and not federally backed? So a 3-day notice to perform an eviction filing?
No. The law now requires a 15-day notice to be served on tenants.
Michael asked, are commercial evictions permissible in 2021 in Alameda County?
As of right now, I believe they are permitted. I believe that the moratoria expired for the county, but then you have to check with each city. So these questions are tough to answer because it's a city by city thing, and every city has a different moratoria. But I believe at the county-wide level, the commercial eviction moratorium has expired.
Tingwei asked, does the COVID law prohibit rent increases? I thought it was just prohibiting evictions.
Some cities, I believe, they have their own prohibitions on rent increases. Clifford will correct me if I'm wrong.
It's city by city. So again, it depends on the city. I think most cities are permitting your yearly rent increase that you're allowed under the local rent adjustment ordinance. But if the tenant doesn't pay it, you can't do anything about it because of the eviction moratorium. But I believe they're allowing those rent increases if you want to impose them, or you could just bank them later.
Christine also asked, is a 15-day notice required to be served by 2/28/2021 when the tenant has not been late?
Could you repeat that?
Is a 15-day notice required to be served by 2/28/2021, February 28th, when the tenant has not been late?
No. So maybe the confusion here is with the informational notice. So the only time you serve a 15-day notice to pay the rent or quit is when rent hasn't been paid. And the only time you're required to serve the informational notice, which is not an eviction notice, is when a tenant missed one or more payments during the covered period of time.
And I understood that SB 91, you would give notice, the information notice to all tenants who were delinquent as of end of January of this year. So if they're not currently delinquent, then you do not give the information notice.
Christine asks, are there any notices I must send to tenants who broke the lease early about their obligation to pay?
Well, yes, if you haven't already served a notice, serve that informational notice. Again, you can get a copy from my law firm website, and that should go out before the end of February. The new informational notice for rents that became due after September of 2020 must be mailed out or served on your tenants before the end of this February. It doesn't hurt to send that out to a tenant who was delinquent before September of 2020. Theoretically, you already served one, but if you haven't, just send them the new notice.
And the final question is, will this video be viewable at a later time?
That remains to be determined. I believe we will make the PowerPoint available to people who request it. So for those of you who are taking photos of the slides, the flashes were hurting our eyes, but we'll make the PowerPoint available to you. We don't know about the actual recording itself. So let me again mention that the information that was contained in this slideshow and the presentation today was general in nature. If you need legal advice, please consult with an attorney because the facts of your case and your situation may be unique. And the law is constantly changing. If you want to reach William, you can reach him at this phone number. Here's Advent Properties web address and other contact information. And here is information for my law firm and myself. If you would like an appointment, call any one of the phone numbers on the screen. Visit our website. We also have a Facebook page, a lot of free information there for you. But if you want legal advice, that's something you'd have to come in, set up an appointment. We'd be happy to help you. We have a staff of people that are available, attorneys who've been practicing landlord-tenant law for many years in many different jurisdictions. I'm sure we have someone that could help assist you. William, anything you want to say as we conclude?
No, I want to thank everybody for attending. Thank you very much for spending nearly 2 hours with us. And we hope that we've been helpful to you guys, at least in some ways. And again, feel free to reach out to Clifford's firm or ourselves if you have questions about what we can do for you. And again, thank you for your time.
Thank you, and better times ahead. Have a good day.
Have a good one. All right, wonderful. Thank you. I believe Daryl has just sent out the email address where you can request a copy of the slides, and we will get that information from everybody, and we will get that sent out to everyone. Thank you so much.